thanks everybody for coming out today. I think this is going to be a really interesting discussion between folks who have a lot of experience in dealing with issues around embezzlement and employee fraud and all the wrinkles and problems that come along with investigating those situations. Before I introduce the panel, I will note that we have CLE credit, self-reported CLE. There should be a little half sheet in your materials that has the information about how to get credit for that. So, without further ado, let me introduce the panel we got for you today. Matt Forsgren is here. He's been practicing at Green Espel for a long time. He has 22 years of experience representing clients in civil, administrative, and criminal proceedings and complex internal investigations nationally and internationally, and has tried dozens of cases to verdict and conducted numerous hearings in state and federal court. He's got a lot of experience, and I know he's going to have a lot to add for us today. We have Josiah Lamb. He is a former forensic accountant for the Federal Bureau of Investigation, and he's an attorney. And he's investigated complex financial matters from every possible angle, including white-collar crimes related to national security. We have some questions about the most bizarre embezzlement scheme you've ever seen. I'm hoping that he has some good ones based on that bio description. We have with us Joe Thompson. He's an assistant United States attorney in Minneapolis, member of the Fraud and Public Corruption Section, responsible for investigating and prosecuting complex financial fraud and public corruption cases. And he previously served for 5 years as an assistant United States attorney in Chicago, where he investigated and prosecuted a wide variety of federal crimes. And then we have Dulcie Foster, who most, if not all of you in the room know well. She has been practicing at Fredrikson and Byron for 18 years, 19 years, a long time. And she's a shareholder in our white-collar defense group. She has experience investigating embezzlement schemes and working for both embezzlers and alleged embezzlers and embezzlees. So she's got a wide variety of experience to speak to as well. Both Matt and Dulcie are co-chairs of the White Collar Crime Subcommittee of the Federal Bar Association. The FBA is co-sponsoring this event, and we are grateful for them doing that. So, let's get started with just the basics, and this is a question that I'm going to direct to the whole panel. Actually, before I get started, we're taking questions from the audience. We don't have a roving Oprah-style microphone, so if you want to ask a question at any point, just raise your hand and I'll let you know that you are okay to speak. There are microphones in the ceiling that should pick up your voice. If we can't hear you, we'll let you know. But feel free at any point to interject, because the goal here is to really have a wide-ranging and fluid discussion between the panel and you folks, and not just me. Okay, so for the whole panel, let's start off with the common. What are some common embezzlement schemes in your experience? What do you see most commonly?
So it seems like it breaks down into 3 general categories. There's your basic garden variety theft, where the employee takes inventory or pilfers petty cash. Those are fairly simple. And then there are the schemes where employees are skimming profits before they get booked. So that's another way to do it. So you're taking in money, for example, payments from customers and booking those at half of what the payment actually was, and the rest of it gets pocketed. Probably the most common one that I've seen is the disbursement scheme, where the employee is falsifying invoices and billing, then turning around and then billing the employer for reimbursement for expenses that weren't incurred, or even creating fake vendors. And usually there's somebody on the outside who's involved in that scheme, where they have a buddy or a relative or a friend who's set up a fake business operation, and they're then billing the employer for that fake business operation services and getting reimbursed for that. So those are, I think, some of the more common types of schemes that I've seen. Got any other thoughts on that?
Joe, have you seen anything in your...
Yeah, I think the latter one, the fake invoice, fake vendor, seems to be the one that at least I incur. I don't speak for the entire department, but my own personal experience, that's the one that seems like that I come across the most often.
Yeah, we've also seen the personal use of credit cards is pretty common, along with running duplicate paychecks to themselves and or running additional bonuses to themselves.
Yeah, mine would be sort of redundant to what's already been said, so I'll sort of twist it slightly and say that when I think of commonality in embezzlement cases, I think of drugs, gambling, and then equally unfortunately mental illness. It's not always present, but you just see those things so often in conjunction with what's already been described.
Okay. And keeping in mind that those are the most common, what's the strangest embezzlement scheme you've ever seen? Let's start with Joe.
Oh boy, start with Josiah.
So there was a guy who stole a couple $100,000 from his employer, and he opened a separate bank account in the name of his sister-in-law. But to get the money, it was one big wire transfer, and to get the money out, the bank required additional verification from this guy. So he calls up and calls the bank, and they recorded it, of course. And so his sister-in-law's name was Kim, and he says, "Well, I'm Kim," and the bank's like, "Your paperwork says," he's like, "Oh, I'm a male Kim, don't worry." And the bank, asked him some questions about where he worked, the real Kim that he set up, and he couldn't answer him, so he had to call back, and then he called his sister-in-law, got some answers, and his wife. He had to call both to figure out more about his sister-in-law, so that when he called back to get the money out of the bank, he could verify that. Because they asked, name 4 employers, 4 businesses, and said, which one did you work at? He's like, I don't know.
Ask him.
I don't know. Yeah, ask him. So the second time they asked about addresses, and they was able to answer that one. So he got the money out, but he was there was a trial last year, and surprisingly, he was found guilty of that. So
Did Kim testify?
no, but the bank did, and they played the tapes where he was Kim.
Impersonated.
So, yeah.
What about you, Joe?
What I always find unusual is not so much the fact pattern of how they embezzle the money, but how they use it. Mm-hmm. I'm always amazed. There are the people that just buy property and cars, but then the people who just blow it. It's amazing how much money someone can steal, and at the end of the day have nothing left. There's obviously the gambling cases. I had a case a year ago where someone stole almost $2 million. She was an accountant from her employer and gambled it all at slot machines at casinos in southwestern Minnesota, which is just a staggering to me amount. And we did the math, and she was spending on average 45 hours a week at the casino.
My goodness.
She wasn't getting comped anything. She wasn't going to Las Vegas, just at the Shooting Star Casino and these local casinos, just pounding money into the slot machine. I had another case where a guy stole a couple $1 million through a fake invoice scheme, and we were onto it while he was still working at the company. And at one point, we're surveilling him home from work one night, and he on the way home from work, he stopped at the Outlet Mall in Eagan. Then he went to the Mall of America. Then he went to an Applebee's. And then he left met a friend, and left the Applebee's after eating, and drove across the parking lot to Red Lobster and ate again. And he paid cash at every stop. And it's crazy that the need to steal millions of dollars from your employers just so you can go on some weird shopping and eating spree every day after work.
Just to eat at Red Lobster. That'd be a good commercial for them. Right?
Yeah.
I think it's.
What are you willing to do?
I think it's really troubling for the embezzlees when that happens too, because there's nothing to recover.
Yeah, it's all gone.
It's just gone. It's been frittered away, and there's no way to get it back when what's happened is a bunch of trips or
the Red Lobster ain't coming back.
Let's hope not.
The weirdest one I was not a participant in this, read about, was the postal worker who claimed he was on jury duty for, I think it was the equivalent of half of a year. And there was no trial, but he was getting paid by his employer to not be at work for half a year because he was claiming to be on jury duty. And it surprisingly didn't get caught until he tried to do it again. So he did it again, like a couple years later. He said, "Oh, got another big long trial," and then the employer, wait a minute, what's this about? And then looked it up and realized he'd actually faked court documents and like gone to great lengths to try to convince the employer that he was actually gone. So
Yeah, the two that come to mind were sort of when I was growing up as a lawyer. The first one just absolutely blew my mind. It was Jim O'Hagan, whose name I think many of you remember from the insider trading case, misappropriation theory that went up to the Supreme Court. But before that, he was just a luminary in the Twin Cities legal community. He was at Dorsey, and I know that the articles described him as one of the top or second producing attorneys there, and he was representing Mayo. And I think that, you know, in that area, you probably couldn't really have a better client if you are trusted enough to be a senior partner at that firm and representing Mayo. So what do? Stole literally millions from them. And I remember one example was he told Mayo, and this is because, of course, they trusted him, that he settled the case for $250,000 when, in fact, he settled it for $25,000. And so he basically pocketed the $225,000. And I wasn't even practicing law when this happened, but the case was winding its way through the appellate process. And I was wondering, what is your defense to that when that happens? And he basically said he had a relationship with an in-house attorney at Mayo who said that it was okay for him to use that money for a while. That didn't go over so well with the jury. And so he ended up convicted of that, and there were other things. But it was always posited that his motivation wasn't drugs or gambling. Well, maybe it was a form of gambling, but it was his investment losses because he was compulsively investing in some things that he should have been, maybe some things that he shouldn't have. The other one was David Moskal at the Schwinn Betts firm. I couldn't believe that one either. I think the estimate was between 1.8 and 5 million taken from client settlement accounts. Just couldn't get my head around that.
So, short of bumping into your employees at Red Lobster and asking them what they're doing there, what are some ways that embezzlement typically gets discovered? We'll start with the employer or client side. Dulcie, how do your clients, when they find something out, typically run across problems?
So I guess I'd start out by saying I'm usually, when I get into these cases, not surprised by the fact that they found it or how they found it, but the fact that it took them so long. Usually there's, I think, a great deal of neglect or just failure to really oversee things. And often I think it happens just by happenstance. Someone randomly double checks something that they would not have normally double checked. And they just said, well, I'm gonna, for some reason that's sort of outside of our normal patterns and practices, I'm gonna maybe call the bank and check the number that was booked under this account and ask for verification for it, and then it pops up. So I think sometimes or a manager sees that his signature is on a document that he didn't sign and realizes that there's some kind of a fraud going on, that there was a forgery. So I think a lot of times it happens sort of randomly. More, kind of systematic way that it gets discovered is when there are good accounting controls put into place, and these things get discovered in the course of regular routine audits, and should be discovered in the course of routine audits. And so those tend to be the ones that don't grow as large, because those are the employers that actually have the checks in place that they should have in order to detect these kind of things.
What about you, Joe? How do these problems typically come to the attention of your office?
Well, people like Dulcie and Josiah call us, and most of the time, I think people take the day off. a lot of, one of the hallmarks of embezzlement is someone who an accountant in a small, maybe a family-owned company, a closely held company that handles all the books and really is a one-person accounting department or bookkeeping department, and they never take a day off. And they're always there to pay the bills, or they come in on their day off to take care of things, because it's when they take the day off or they take a week off that someone else is in there looking at the books and realizes that they're in shambles and they're a mess and there's money missing. So we often hear from other people that the weirdest way we ever got turned on, or I saw an embezzlement caught, was a case where someone had hacked into a company's computer and wired $500,000 from the company in Minnesota to Hong Kong, and it happened from using a certain employee's account, and so the company saw $500,000 missing. That was a lot of money. Called the employee in and said, "What happened?" And she said, "Oh, I didn't do that. I don't know anything about it." And during that conversation, at some point, she said, "Well, when you start looking at the books, you're going to find these checks," and then admitted that she had been embezzling from the company. Turns out she was not at all involved in this $500,000 wire transfer. Some people in Asia or Russia hacked into her computer and wired all this money and just happened to pick her account. It's not her day. But I guess it goes to show you they can get caught in any which way. But the typical way, I think, is people that eventually they have to take a day off, or someone else comes in there and gets to looking around.
You mentioned that one way that you find out is that an attorney for a company will come in and let you know there's been a problem. We talked about this before the panel today, and I'd be interested to hear everybody's opinion on this. How do you decide? Well, first of all, do you recommend that companies come into the U.S. Attorney's Office and say, "We got a problem here. Our employee's been spending millions of dollars at the Shooting Star Casino, pouring nickels into the slot machine"?
Of course. Yes, you should come tell us if you are a victim of a fraud, whether it's embezzlement or something else.
Always? I mean, do you think that's 100% of the time?
Well, I mean, I don't know why you would not want to talk to us for such reason. I don't see any downside, frankly.
Okay.
I'll leave Dulcie at that.
Yes, are there any
Spin a
contrary
story.
opinions on the panel?
Yeah, we might have some differing views.
There are, but I mean, it's one question is you ask how do we find out? Well, sometimes we find out only because the client has chosen to tell us in a privileged setting without, and the next question is going to obviously be, do we tell anybody else? And you tend to remember things that happened to you for the first time. I remember the first time I was contacted by somebody who was a victim of embezzlement. And this is somebody who is responsible for managing millions upon millions of other people's money. And so when this individual told me that, in this case, he was the victim of embezzlement, it was not something he wanted to tell me because he was so intensely embarrassed. And so then once you have that conversation, then the question becomes, well, do you report it to law enforcement? And I would say that, at least in the area of law in which I practice, this is one of the most intensely client-driven decisions. If there's any sort of perspective I have about whether I advise a client to do it or not do it, I would simply say I make sure that if the client is going to make that report, that the client does so with eyes wide open. And it's going to be on the client. Of course, there's the very basic discussion of, do you want this to happen to somebody else? Because embezzlement is really just a very difficult and painful crime, because setting aside the money that's lost, hoping, well, maybe there's insurance, but oftentimes there's not. But setting aside the financial issue, it's the betrayal, the loss of trust. And whenever I've been at sentencings for persons who have committed embezzlement and pled guilty to that, when you hear the victim impact statements, that's like the first thing that you hear is a discussion of the loss of trust. So the question to the client is, do you want this to happen to somebody else? And they've been kicking that around for a long time. So oftentimes the considerations that happen, despite no matter how reasonable you are, Joe, the client is going to kick around these things, among others. One is there's often confidential information that they're concerned about, not just the fact of an embezzlement, but just confidential information. And sometimes, well, in a criminal proceeding, as we all know, it's very difficult to keep information confidential once there's a decision to prosecute. There is the reputational harm or the embarrassment. I've touched on that already. And then the last thing is this, and this is consistent with the eyes wide open comment I made. Once the decision has been made to report, one thing I always say to my clients is just beware. It's going to be Mr. Thompson now who's making the decision with his agents. You are now in a consultative role. You're a witness, but you are going to be not making the decisions another person is, and just bear that in mind. And then they make the decision that they make. And sometimes on a personal or a human level, I agree with it. Sometimes I don't, but it's their decision.
So I usually look at a couple of other factors in addition to the ones that Matt was just talking about. Number one question is what's involved. How much money is at stake? If it's a small amount of money, frankly, I don't think Joe's going to return my phone call if I tell him that my client was, embezzled a couple $100. And so, that whether or not you think it's actually worth the time to try to report it because of the circumstances, it may be a factor that you want to consider. The bigger question, I think, is that you always have to open your client's eyes to is to what extent is making this report to law enforcement going to expose my client to liability, either criminal or civil liability. So, for example, let's say the embezzlement is discovered in the context of an investigation that the company has launched into sexual harassment allegations that the embezzler has already filed against the company. Just by reporting it to law enforcement, what kind of employment claims are you opening yourself up to? What are the retaliatory allegations that they can make and the scope of that, and what embarrassing and bad stuff about the company might come to light if you contact law enforcement in that context. This is something that clients need to consider. I had an investigation that I handled years ago for a company that was initially contacted us because they have foreign corrupt practices issues, some pretty serious ones, and there was an ongoing investigation into those. And in the context of that, a discovery was made that a computer IT manager for the company was doing the fake vendor scheme. He had a buddy on the outside that he was sending all kinds of bills to, that he was getting payback kickbacks from these payments for software that the company wasn't even using. And so there was this other crime that was going on. Ultimately, that company ended up self-reporting the FCPA issue, and the embezzlement was prosecuted, and the embezzler was convicted. But I think before you sort of launch into reporting the embezzlement, you got to think about it. This is going to open up all of our records. We're not going to be able to once we tell law enforcement that there's an issue here, they're going to start asking for our accounting records. They're going to start asking for all kinds of data. Are there concerns there? You have to really think about that before. And you're not doing your client a service by running out and exposing them to liability. It's your job to look for those pitfalls and warn them about them before they report. Sorry, I know you want to hear about all that. But.
I mean, just to rebut here, those are obviously concerns, and I fully understand them. I do think one of the things that Matt pointed out is important, though, that embezzlement is a crime of betrayal. I know there are a lot of people that will do it, and if maybe they get fired from the company, it doesn't get reported, they'll go on to their next employer and do it again, and that is a significant factor and thing to consider. And I think it's important that people get reported and prosecuted for these types of crimes for that reason. Things like reputational harm, private data. I know, in a lot of our cases, generally in the white collar context, involve those issues, and often we're able to do things to address concerns. That's why victims often have attorneys or people like Waypoint involved, is to guide them through that piece of the case. Whether it's protective orders or just being sensitive to confidentiality and to adverse publicity is often something we can do. I haven't, obviously, as an office, we make, our decisions, and it's true that we, once we have a case, to some extent, we're handling it. That's true. But it is with input, and I have cases with Dulcie, and we talk on the phone regularly. And lots of other attorneys in the room have had embezzlement cases with, and we have communication, and when there's concerns, we do our best to address them. And I think generally, I've always been able to deal with those. I had an embezzlement case last year that involving a company in town that was very sensitive to the publicity, and ended up, in cases we might have done a press release, sometimes we ended up not doing that. And it's not something we necessarily always walk away from, but we decided in this case we could. And there's reasons for that. And so I think often, we can be sensitive to those things and work something out that works for both sides.
And I think that's generally you guys try, but at the same time, it's hard for me to tell my client up front before they make the report how I know you're going to handle that press release, right? That's something that they kind of walk into without knowing really because we're not calling that shot. That's you.
There's another dimension to it as well, which is something we haven't touched on, which I know that certain clients will decide actually to make a report to your office as opposed to making reports to local law enforcement because they have more confidence in your office's expertise and ability to get things done in a way that doesn't backfire on them. And I think most of us in the room know that your office does have to manage its resources, and there at least have been sort of informal thresholds. I know one of my clients didn't make one of those ones, but long story short, making sure that, to Dulcie's point, that it's a significant enough event where it's going to get the attention of people who can do good work on it is a factor.
Josiah, when people are thinking about bringing their clients in to talk to the government, and even before that, when there's just suspected embezzlement, what are the red flags that folks should be looking for so they make sure they're ahead of the game and know what's going to come up once people start looking more deeply into this kind of problem?
There's a whole host of things you can look for when you've got a problem. Typically, it's with someone in accounting, someone with control over financial aspects of the company. What we see most often is individuals are unable to perform their job, their basic tasks. They can't reconcile bank statements. They can't, their actual performance to their budget performance are way off because they're putting their embezzlement in some sort of expense category or putting it on the balance sheet in a prepaid or an accrued expense category. One thing we've seen a lot lately is related party transactions where a spouse or a cousin or a distant relative has a vendor relationship with the company that the person's at, and overpayments get made to those related parties. There's missing supporting documentation, no receipts for their expenses. We talked about that previously. Missing purchase orders, etc. There are lots of, you can go down the list, and every case is a little different, but there's some pretty standard things that pop out.
Once the investigation is kind of underway, it can go in unexpected directions and start to envelop people that you didn't imagine it would envelop from the beginning of the investigation. And so this is a question for Matt and Dulcie, and for Josiah too. Once that happens, what do you do to protect the independence of your investigation if it looks like somebody who's in a management role or C-suite position has been connected to the problem?
Go ahead, Dulcie.
Okay. I think it's important at the outset to anticipate this type of problem potentially coming along. And if you're working with a company that has a board of directors, and there's any risk at all that the CEO might be involved in misconduct, You should be not reporting to the CEO. You should be reporting to the board of directors or a special committee of the board of directors to make sure that you are getting your orders and instructions from somebody who is out of the potential risk area for having participated in the conduct, or even being a significant witness to the conduct. So taking the steps of making sure that you're going far enough up the management chain in terms of how the investigation is being structured is probably the biggest thing.
Do you let the individual management know that you're doing that? Do you kind of change the way you communicate with them? How do you manage that relationship?
I think you have to. I mean, I think you have to go to the board. You have to report, and if they're going to know. I mean, that's not the kind of thing that you can conceal from the manager or whatever of the business. You don't have to tell them why, but the need for independence is enough, I think. I don't know if Matt has anything to add.
Yeah, I think further to what you just said, I think a lot of people look to audit committees as the appropriate committee to work within these scenarios, particularly given what audit committees typically have to handle. They just seem like a natural fit, but special committees, as Dulcie observed, also can be useful. In any investigation, you do have to anticipate that there's going to be a problem down the road if other people are implicated or have to be investigated, and the integrity of the investigation, not just for you as a lawyer, but for the organization, is going to be compromised if you don't take these measures in advance. Just as you said, Dulcie, if you don't anticipate these things, it can be a big problem.
There's kind of an inverse to this scenario that the government faces, where if the government and the company are in communication, the person who's allegedly embezzling could accuse the government of allowing the company to influence its investigation or inject bias into the process. Have you had that come up, Joe? And what are your thoughts about how to mitigate that from your side?
It's always a risk in a case like this. Embezzlement cases or any case where you're in regular communication with a victim, there can be that insinuation that we're doing their bidding. To me, I just always try to make clear that we don't work for the victim. We don't work for the victim's lawyer. We are doing our own investigation, and we try to do it separate. So we often have communication with the victim and the victim's attorney, but often that's somewhat a one-way street where we're getting information from the victim, but we're not sending information back to them, and that's important. That it is a one-way street, and we do our investigation on our own, and we draw our own conclusions.
I represented a corporate victim recently where that type of allegation came up against the prosecutor. This was not a federal case, so it's nobody from your office, but it was a situation where the company came forward. They made all kinds of allegations. They provided lots and lots and lots of information to the prosecutors and the law enforcement officers who were involved. And I think because the particular law enforcement agency that was at issue conducting the investigation was not as well resourced, frankly, as the U.S. Attorney's Office is, they had a greater tendency to try to offload the work of the investigation onto the client. And the result was that there were statements in the complaint that were just simply reiterating things that the lawyers for the company had told the investigators. They hadn't gone out and actually done their own interviews, and that was reflected in the complaint. That created huge problems for the case, and it gave a lot of legs to the allegation that the prosecutors were just doing the bidding of the corporate interests who were trying to get the case prosecuted. So I think it's important, if you're on my side of the fence and you're advising the client, not to let them do that, not to let them run the show and push things. I think the independence is advantageous, not just for the prosecutor's office, but for the defense attorneys as well, because it impacted the case in a negative way. And
it is an important thing, I think, when a company comes forward or has a lawyer and they sort of turn it over to us, that our understanding that they are turning it over to us, and we're going to carry out the investigation from that point forward, and there'll be some consultation, there'll be communication, but at the end of the day, it's the U.S. Attorney's Office and whatever federal agencies we're working for that are going to conduct the investigation and draw its own conclusions and make any charging decisions if we get to that point.
That could be extremely frustrating if you have a client that wants to know what's going on every 5 minutes, because you can't tell. I mean, once we let them run with it, we've got a wall there. We can't, the client has to understand that they're going to lose control. They're not going to be able to inform their shareholders, their constituents about what's going on. That they're going to have to sit and wait to some extent without having a lot of information, and that can be a difficult client management challenge.
No hands have gone up, and we've been talking up here for like 40 minutes. So before I go on any farther with my own questions, let's take an opportunity. Does anybody have any questions they want to ask right now based on what we've heard so far? Yes, Mr.
On that last point, there are instances where like the company will have to do its own investigation for its own purposes. Delcy, you mentioned the SEC, and so I'm wondering how you all manage sort of the parallel track, because there is some challenges around that. I know that the U.S. Attorney's Office would like to sort of go off and do its thing, but the company may have its own obligations. How do you manage through that?
I see there's being a distinction between what I will refer to as a defense-oriented investigation and an internal investigation. I mean, oftentimes these things blur. But in an internal investigation where the concept of independence is preeminent, you take the measures that we've already discussed. But I do think that there are other investigations where lawyers are desperately trying to figure out what's going on, and they're investigating while still trying to defend at the same time and be an advocate. And that's extremely difficult. Those sorts of situations raise all sorts of additional considerations about trying to do the best that you can to figure out the best way to advise your client, while on the other hand, dealing with an enforcement authority, whether it's a criminal enforcement authority or a regulatory enforcement authority. But for me, I think that I'll back up and say there are sometimes situations where an internal investigation will reveal there's a problem. And so the question often arises, do the lawyers who are handling the internal investigation, the investigation where independence is critical, do those lawyers then drift into the defense role? And it's decided on a case-by-case basis by the folks involved, but from my perspective, I don't think it's generally a good idea for somebody who's doing a truly independent investigation to drift into that defense mode because of the possibility of witness issues, and there are other ethical issues that arise. So, Joe, I think the question that you raise actually implicates one of the most difficult, or it implicates a host of difficult questions when you're doing investigations, either to try to give an answer to a corporation or to defend the corporation.
Anybody else have a question before we? Okay, so with that in mind, one of the primary concerns when you're engaged in that kind of parallel investigation is privilege. How do you protect it, and how do you decide what to share and when to share it, and make sure that what you're sharing doesn't end up biting in the butt later on?
I think another client management issue, I think, if you're the private attorney that's representing the victim, the first thing you should do is educate your client on what the privilege means, and let them know that anytime you open your mouth and talk to the prosecutor, that's not a privileged conversation. And I think that I've worked with clients who have a misunderstanding, but we're all on the same side, right? So we're all trying to do the same thing, and it's okay for me to just say anything I want to say. And I think it's really important to be careful about the possibility of a broad waiver of your internal investigation happening inadvertently by sharing too much. It is preferable to have lawyers communicate with lawyers and not have the clients speaking directly to investigators, except in the context of a formal interview where they're providing information and it's known that information is going to become a part of the investigation of the government is doing. And to just educate them about the risks of oversharing, and instead take the approach of pointing the government investigators in the right direction. Like where should you be looking, and have them go do their own investigation, as opposed to sitting down and sharing the notes of your interviews that you've done internally. Because if you do that, you could lose pretty much all privilege covering what you've done for the company, and your ability to protect the company from the exposure issues I talked about a while ago is significantly diminished when that happens.
I think embezzlement cases actually are just a perfect example of how this plays out, because oftentimes embezzlements, particularly currently, are done in a very sophisticated way, in a very unfamiliar way. I always wish I knew my clients better, but then you deal with somebody who's prosecuting, and they don't know your client at all. So what do you want to do? You want to help the client out by putting together a presentation that walks through exactly what happened to your client. That's the best way to serve your client. At the same time you're doing that and working in conjunction with somebody like Josiah, you have to be aware, as Dulcie said, that every bit of work that you do, that you hand over, back in the day, maybe it was a 3-ring notebook with tabs and charts and diagrams and exemplar documents. Well, you have to imagine that every single bit of what you are turning over could be an exhibit at a criminal trial down the road if you happen to be right about what's happened. And so embezzlement cases, frankly, come immediately to mind in situations where I have put together those materials for the client, thinking, we are taking a big step here, aren't we?
How does this issue inform what you do, Josiah, in your work?
Oh, we have to be careful with how we communicate with the lawyers we're working with and people we're talking to, because typically we're in the offices talking to various people, including upper levels of management, and they all want to know what's going on, and we have to be sensitive to anything we share with anybody about the investigation, because we have the potential to lose attorney-client privilege over what we're doing, and so comes into play with just about everything we do.
Have you ever been in a situation where an attorney was going to share something with the government and you thought this was a bad idea and either objected or just sat there with, thinking this is not going to go well?
There's a few attorneys in here that I work with, so I'm going to plead the fifth.
No one in this
on
room,
that
of
one.
course. No one in this room, of course.
Right. No, it happens. It happens where we have differing opinions on what we should share and what we shouldn't share. But
Are there things that attorneys could do in working with you to better communicate about these issues, about what the scope of your investigation should be, how we should keep privilege protected? What can the folks in this room do better in working with you?
I don't think there's anything that they can do better. I think everyone's got a pretty good understanding of how serious attorney-client privilege is. It's just a matter of if you share it and if you share it when. And everyone we work with has a good handle on that.
A question, Tim? Oh, I was raising his hand.
Did a hand go up? It's like an auction. So,
There's one.
yes.
Matt, you mentioned insurance, and I just asked the panel if you're the attorney for the victim corporation and you want to preserve and pursue an insurance claim, at the same time you're doing internal investigation, maybe you're dealing with the government, maybe you have employment issues as well. How do you kind of deal with that, in particular insurance?
From my perspective, it's another eyes wide open situation, because I can think of civil cases where going into the insurance file has resulted in some of the most disconcerting moments in my own practice. So with the client in a criminal case, it would be a very similar analysis from my perspective, which is glad you got coverage. Not everybody does. Good work, but do you actually want to use it because of whatever might play out between you and your carrier, or whatever you might have to disclose to your carrier? Somebody like me, when I'm in defense mode, I'm going to want that. And there's always a risk that I could actually get it if I'm in defense mode. So it's terrifying from my perspective.
Dulcie?
Yeah, I mean, I think you have to tell, from the attorney's perspective, you tell the client what the risks are. You talk to them about it. They have to make their own decision about how much to share if they really want to get the claim pushed through, when they want to get it pushed through. Sometimes it's better, frankly, for the claim to wait until the case is further along and closer to becoming public. Clients don't always listen to advice about that, though, and you have to, some extent, let them just understand what the risks are and make their own judgment calls.
From the government side, Joe, how do you decide how much to share with lawyers for the company?
It's a case-by-case basis. I mean, like I said before, I mean, it's largely, information sharing is largely a one-way street from the victim company or company's representative to us. I try to share as much as I can, but we always are independent, and we always want to be not only perceived as independent, but actually be independent of the victim. And when we're conducting a grand jury investigation, if that's what we're doing, we obviously can't share that. And I know that can be a point of frustration for clients. I think sometimes they're attorneys too, but I think it's often they're just getting calls from their clients, and I probably get called one every 10 times. Someone like Dulcie gets called. She calls me once. I try to share as much as I can. I mean, every AUSA has their own personal comfort level with what they can share. There's legal limits on what we can share. I try to give people a sense of where we're at and timing, but often we don't know. And when it comes to grand jury investigations, there's a lot of stuff we're legally prohibited from sharing.
So once you've discovered the scheme and it's been discussed, both sides are kind of, the company and the government are pursuing their own independent paths. At some point, action has to be taken on both sides, right? So what kind of federal laws come into play, Joe, in a typical embezzlement prosecution? And how do you decide what to employ?
Well, wire fraud and mail fraud are generally the ones we use. I mean, there are other ones you can use. I mean, I think, again, every prosecutor has their own preference as to which statutes they charge. I like to keep it simple because I know what wire fraud and mail fraud are. And so I try to jam everything into not wire fraud and mail fraud.
Isn't everything mail fraud?
Everything is mail fraud and wire fraud. Why get fancy? I mean, I think those are the ones we generally typically take. Which one depends on how we want to establish our jurisdiction and can we find any real mail to use. Beyond that, it's really how you draft the indictment in terms of the allegations, and that's just on a case-by-case basis. And sometimes the scheme is colorful, and you want to include that in an affidavit because it'll help you if you're going to trial, or it'll catch the attention of the press, or get the defendant's attention. And there are other times when there are other concerns, and you want to dial it back a bit and make it a little more clinical and look like a straight-run-of-the-mill case, and it will draw less attention, and that is a case-by-case. There's a whole host of factors that we consider when we decide what to include in an indictment or how to draft an indictment. And embezzlement cases are no different than other ones in that regard.
Matt and Dulcie, what about on the company side? Once you've got a scheme identified, what do you typically do to help the company move forward?
I think so there are several different ways of approaching it. It's always case specific and client specific, but you should be trying to get out front of the facts and learning as much as you can, because as Joe said, the information is a one-way street. You give them information, they don't give us a whole lot back, and if the client is anxious to know what's going on. If there are internal constituents who need the information, you need to be doing your own investigation to find that, because you're not going to get it from these guys until after the case is indicted. So that's one consideration. Managing media inquiries, it tends to be an issue in a lot of these cases, and many of my clients are media averse and don't want to have things appear in the press, and so trying to figure out how to manage inquiries from the media is another issue. Of course, spotting the potential liabilities to the client, not just parallel, the potential for criminal risk to the client that might come out of the case if the embezzler has done some things that are against the law on the company's behalf, which often happens along with the embezzlement, but also civil liability that could, for example, come to the board of directors or the company management for failing to catch the embezzlement sooner. There are all kinds of legal pitfalls and risks that have to be dealt with, in addition to dealing with educating the clients about privilege, and then finally, and I think maybe most importantly, helping to manage inquiries from the government about for information, which are going to be continuous throughout the course of its investigation. They're going to be looking to talk to witnesses. They're going to be looking to review documents and information, and I see it as my job to help shepherd the collection of that information and make sure that it gets provided in a timely manner so that the case can get prosecuted.
What you meant?
Yeah, I think the continuing vigilance after the report is essential for all the reasons that Dulcie explained. Another thing, though, is, again, sort of, many of us here play a number of roles in these situations, and in defense mode, we know that embezzlement cases are very difficult to defend. I mean, they're just very difficult cases. In fact, they're just challenging on so many different levels. But one thing that we watch for on the defense side is what you asked about, Kevin, which is there too much interplay between the victim and the government, and is there coordination of litigation? And we know that there are some judges who have gone on record when there's coordination between, for example, the SEC and the DOJ. So we're aware of this. Well, if you're counseling a client about how to make sure it's protected when it makes a report to federal law enforcement, if you take those lessons into account, one thing you do is try to implore them to understand to stay out of the way, because they've got a job to do, and if you've handed that job to them, one way you can really muck it up is by insinuating yourself too much. It not only drives them crazy, but it also could compromise the client's interests if what the client wants is a result that is conviction or something like that. So it's kind of awkward to draw on both of the disciplines, but at the end of the day, as Dulcie said, client management is challenging in these cases because you really do have to emphasize to the client to just stand back and let others do their job.
Josiah, what about you? I mean, do you have remedial controls and things that you commonly discover should have been implemented and recommend it get implemented?
Yeah, in these embezzlement cases, the one thing everyone should advise their clients is to not use signature stamps. Signature stamps are awful. We've seen it in more than 5 cases in the last year that somebody's using a signature stamp and writing themselves checks, and no one's reviewing it.
Thank you very much for saying that.
Yeah. You do a simple code of conduct and pre-employment screening for a company's employees with any ability to get their hands on cash or checks or payments. It's amazing what comes out in pre-employment screening. Sometimes you see the embezzler who got off the first time and is trying to come to your client. Sometimes things like that pop up. Timely bank reconciliations, just timely accounting functions. One thing a company can do is keep their eyes open as You know, if their accounts payable clerk comes to work in a $95,000 car, you just want to start asking questions. You know, maybe it's legitimate, maybe it's not. But those are some of the basic controls.
You know, one thing I routinely hear from victims, companies that are victims of embezzlement, is we're a family company. We consider our employees our family, and that's a wonderful concept, and it's wonderfully true, I'm sure. But when your family company becomes big and is bringing in millions and millions of dollars a year, you need to have some controls like a real company, and you can't just get by on the fact that we're a company. Oh, I've known this person forever. You know, once you get to a certain size, you can't just have the one bookkeeper in charge of things. I mean, this is why you see like Little Leagues get embezzled from, and school PTAs get embezzled from, because there's one person in charge that has access to the checkbook, and they just see extra money in there and they start stealing from it. Again and again, we see these companies that started out small and they're closely held, that they're a family company, and they get bigger and bigger, and they have one person handling the books initially, and they grow up and the company's bigger and it's more complex accounting. And then it takes years to figure out that this person's been stealing from them for whatever personal reasons they went down that road, whether it's gambling or alcohol or mental illness or just greed or financial crisis. Give me any of the reasons. But the clients, they consider themselves a family company. At some point, you're not, and you need to get on board with the idea of having some real internal controls.
One curiosity I have, since we have lawyers in the room and other professionals, what I've seen in our community is law firms getting targeted, particularly small law firms getting targeted. And it's kind of amazing how people go from one smaller firm to the next. And I think it has a lot to do with what you said, Joe, but I think it has a lot to do with a sort of particular vulnerability that we have, where we might be so worried about our client's business that we don't really mind our own as much as we could. And in terms of unreported embezzlement cases, I'm aware of quite a few relating to law firms.
I'm actually curious what Josiah has to say about this question. Smaller businesses, I think, tend to do accounting reviews more often than full audits because it's cheaper. You think that's a good idea, or is this part of the problem?
It depends.
Yeah.
It really depends. Reviews, do we have any CPAs? Reviews are fine things because oftentimes a bank requires a review or an audit. But if a bank will accept a review, you do it because it's a lot cheaper. Audits aren't meant to detect fraud, aren't meant to detect embezzlement. Sometimes they do, oftentimes they don't. Probably 75% of our cases are companies that have audits where it goes undetected because typically the embezzler will figure out what the auditors are looking at and work their way around it. That being said, I'm not a fan of reviews personally. A company gets a report from an auditor, and everyone says, "Yeah, we're audited. We're audited." Well, it's a review. In a review, they basically take the financial statements you give the accountants. They do some analytical procedures. They don't verify anything, and sometimes they do. We have an instance where they didn't. But then you get a report. It's got a nice review opinion, and everyone thinks they get a clean bill of health and there's no fraud because they have this review report. Well, they haven't done any fraud investigative procedures. They've asked fraud-related questions, but oftentimes, if they're asking the embezzler's lying to them, or management above the embezzler just doesn't know about it. So I'm just not a fan of reviews. But
Any other questions from the audience?
I had a quick comment, Josiah. That was something very, very astute what you just said. I lead a forensic accounting practice, and with 4 different offices around the U.S. But probably we've seen a large uptick in the amount of engagements that we've seen for law firms, small, locally owned law firms, or medical practices. So high value of money, high volume of money, high volume in some respect to transactions, but medical practice is a substantial amount of fraud, usually by a medical practitioner against existing partners. We actually have an interesting case right now that it didn't actually go to trial, they settled. But it was a local family-owned firm, much like what you had mentioned, Dulcie, with a family-owned firm, have been in business for nearly a century, and everybody gets along really, really well, and they're all family, and Thanksgivings are really fun, and Christmases are fun, until a cousin of the president of the firm, into his 70s. We don't even see there's no age bracket. I mean, 70-year-old guy committed fraud. And the client called us because she suspected that he had misappropriated money through the use of a company credit card. So she called us and through counsel and asked if we would look at a couple of credit card transactions. Within 8 hours, it was just that kind of a gut instinct. We looked a little bit further, and I called the client and I said, do you mind if we look at a couple of years of American Express transactions? The couple of years turned into 5 years, turned into 7 years. Then we looked at bank statements. Well, the fraud that turned out to be, was it 24,000? Was estimated at 24,000, finished off at $2.1 million. Wow. And it was insane. And she was very concerned. The company was very concerned about keeping everything private. They didn't want the negative publicity, so that involved. But she wanted the fraudster to pay the price. So needless to say, Thanksgiving around the family unit got very interesting in this case, and the settlement was much less than the actual amount of the fraud because he had no money. We're working on a matter right now that's really interesting. Is out of our Virginia office. It's a company, about $400 million company, privately held, reached out to us because their CEO, who was a group of shareholders, reached out to us, 12 shareholders, which I believe there are 13 total. They reached out to us because they suspected that the CEO of the firm had committed fraud, but was committing fraud for several years. And these are non-sophisticated financial individuals. They're not at all. They've undergone a review, so they kept calling it an audit, and they put extreme amount of reliance on what they felt was this audit, but it was a review. As a result of what our initial analysis showed that there was an extreme amount, about $18 million in fraud, about the first 3 years by the president of the company. Shareholders voted the CEO out completely, forced him to separate from the company, at least pending the investigation. And that allowed us to a certain amount of records in the company. They had an interim CEO. And within 3 weeks, the two of the shareholders who were very close friends with the then outed CEO voted him back on. So he was taking over the company again. But the investigation that we were performing was engaged by the company and the shareholders that is now back to being led by the fraudster CEO. So we separated on an interim basis, and of course everybody lawyered up. But there was several legal issues involved, and the CEO was then ordered by the court to continue the forensic review. And the CEO called me one day and he said, "Listen, I'd like to see your interim work, I'd like to see the analysis, see your work papers and everything like that." We stepped back completely because we were told that we just weren't going to allow him to prepare the defense in this case. But again, a small company, and it's almost storybook. You can see it, but nobody wants to self-report because they're afraid of other things that may come up that they're not aware of.
Yeah.
So with that, we will probably need to conclude because the beer is getting warm out in the hallway. So let's have a round of applause for our panel.